Hello everyone. I see people are having a stretch break. I'll just briefly introduce myself. My name is Sayani Rananga. I'm an academic staff at the Department of Computer Science, the University of Pretoria. I'm also a senior lab member at the Data Science for Social Impact Lab at the University of Pretoria, and recently a research fellow at the African Institute of Data Science and Artificial Intelligence at the University of Victoria. So I will be the moderator of this panel this afternoon. And with me, I am joined by Zinzi Shabangu, who will be focusing on IP and data governance. And I have Hannah Brown, who will be focusing on Indigenous knowledge and application. And I have Kunjan Hamza Monankri. I hope I'm pronouncing that well. But I'll stick to Hamza for the afternoon, who will be focusing on legal and accountability. So basically, this panel discussion will be on three themes: ethics, law, and deployment. This morning we discussed a lot about data, but then now this afternoon we're going to talk about what are the ethics of this data that we are all talking about? What does the law say? And in terms of deployment side. So without wasting any time, I will give our panelists to just give a brief introduction of themselves. Who are they? What are they currently focusing on before we engage further into the panel discussion? I'll start with you, Zinzi.
Good afternoon, everyone. My name is Michelle Zinzi Shabangu, and I am a master's candidate doing my master's in intellectual property here at the University of Pretoria. And I'm also a postgrad research assistant at the Data Science Law Lab. And thank you for having me.
Good afternoon, everybody. Good afternoon, Siani. My name is Dr. Hamza Muntari. It's Muntari. I am a university lecturer at the University of Bamenda in Cameroon, but equally a postdoc fellow here at UP. I'm affiliated to the Data Science Law Lab. It's a pleasure being with you here. Thank you.
Hello, my name is Hannah Brown. I'm a third-year PhD student doing my PhD in business management under the supervision of Professor Sonali Das, who's over there, and Prof. Marie Hutting, who's part of the informatics department. I'm doing my PhD focused on how Indigenous crop farmers can gain access to essential climate services and business management resources using digital tools, which include AI. And last year, we actually were able to collect data from 120 vendor-speaking farmers. So part of that survey was the recording of 5 questions each for each farmer. So we are sitting on about over 240 minutes of audio recordings in Venda. So yeah, that's me.
Just a point of correction, Hannah, it's Chivenda, not Venda. Okay, so to kickstart this panel discussion, just have some brief remarks. So as AI is moving into real use cases, the challenge is just not building systems, but building the systems responsibly. So today in this panel, we are going to indulge on exciting conversation where we explore the social contract of African AI and how we move from digital extractivism to digital stewardship. So to anchor our discussion this afternoon, we'll focus on 3 themes as mentioned. Ethics. Ethics basically ask us what is right. And law defines for us what is enforceable, and deployment is where everything is tested into reality. So I have a question for Hannah to start this conversation this afternoon. How can we use AI to engage with Indigenous or community knowledge without losing context, meaning, or ownership, according to your experience?
Thank you, Siani. So as we've been speaking about this whole day, Indigenous knowledge is not just information or words. It's more, culture and context and nuances is embedded into it. And also for the people that are using Indigenous knowledge, it is central to their lives and their actions and their lives. And we could see this in the data that we collected last year. Over 80% of the farmers were using traditional knowledge as a source of their agriculture information. So with AI usage, whether it be with translating or analyzing data, or even trying to develop tools for these communities, there is the risk of AI perpetuating biases and generating hallucinations and misrepresenting data. So it's really important, and it's actually should be the first priority that the community you are working with is always directly involved in the creation and the data collection and just your project in general, in every single stage, and even at the end to verify what you have collected and if it is authentic and accurate.
Interesting indeed, and especially seeing the extensive work you did on my home language, Chivenda, with the farmers there. We will talk more about the work you've done, but for now, let us go to Zinzi. Zinzi, what are your thoughts on the legal and the governance mechanism that are needed to ensure that community knowledge is protected and not exploited? Taking, for example, Hannah went to the field, collected Chivenda data from the farmers in Limpopo. So, not in that context of farming, of course, but with your experience, how can we ensure that this community knowledge is protected and exploited? Because you're from the legal side.
Thank you for that. So I think from a legal perspective, the starting point should be copyright law. So copyright law is essentially the body of law that protects things such as written material, such as artistic work, such as musical works. And it essentially gives authors the rights, several rights, exclusive rights. So such as the right to reproduce that work, such as the right to adapt that work. So when you are gathering sources, when you're gathering information, it's very important to consult with the authors of that work or the people from whom the information originates to get information, to use that information, to use that work, to reproduce it, to adapt it. So in the AI context, we hear a lot about data sets, algorithms, models, and so forth. And there's a constant reuse of data sets. So it's important for AI developers and researchers to get permission before they use those works, right? And an important extension of copyright law is the issue of licensing. So licensing is about how to commercialize information, right? So it basically allows copyright holders to control how their data is shared, how it's used, how it's adapted. So, for instance, there's the Creative Commons licenses. So there's several commercialization orientations. So they dictate how others can use their works. So for instance, if you had a work, so and then you wanted to commercialize it, you could put like a attribution condition. So if someone else wants to use their work, they have to acknowledge you. Or you could put a limitation in as far as commercialization, so people can use your work, but they shouldn't commercialize it. They shouldn't use your work with the view of economic gain, right? So there are various approaches that are emerging in as far as licensing. For instance, the Noodle license, which is co-developed by Professor Chijioke Okori. So this license basically emerges in the context of exploitative data practices, where the global north basically takes the global south information and then they commercialize it without any benefits coming back into the African communities. So the Noodle license essentially makes a differentiation between African users and users in, Europe and China and so forth. So licensing is a very important aspect in as far as controlling how other people use your work, controlling or rather reducing exploitative data practices. You control how other people subsequently use your information. Thank you.
That was a mouthful, Zinzi. You made me think about my sins as a computer scientist. I've used a lot of data, and thinking about what you've just said, I ask myself, will I be in trouble if found? So the next question is in line with what I just said, Hamza. So if such knowledge is misused or misrepresented, what forms of legal accountability should exist from your perspective as a law aspect?
Okay, I will start with a disclaimer. I have little or no knowledge on tech issues, so I will limit myself strictly on legal matters. Okay, so if such knowledge are misused or misrepresented, the forms of accountability will depend on certain factors. So before I give the forms of accountability, it's good for us to understand these factors first. Misuse language models or misrepresented language models depends on whether it was done recklessly or whether we can attribute malice to it. If it is reckless or careless or negligence, then the forms of accountability go civil. Okay? If we have malice attached to it, we are talking about criminal accountability. For example, you can have a system developer who misuses an AI system with the intent of duping someone, for example, or causing harm or injury. Then such a victim can have recourse to criminal law. Okay? But now, if that act was reckless, negligence, we have civil claims which the victim can institute for damages which permits redress. So the forms of accountability in civil matters, we have tortious liabilities. For example, he can have an action in negligence, for example. He can have an action in nuisance, okay? We can have an actions in vicarious liability, all right? I hope we understand what this means, or I have to explain what they mean. Should I explain? All right, I will explain. You see, the law already imposes on each of us a duty of care, all right? Now, if you breach that duty, you are considered as a tort vessel. All right. So AI developers have the duty of care towards the users to ensure that those systems don't harm them, don't cause loss to them, don't cause injuries to them. So if you develop a system, for example, which causes loss to me, I am a victim. I can take a civil action against you, the AI developer, for redress. And that action could be in the form of negligence, for example, in which I am taking legal action for your recklessness in developing that system because your recklessness caused harm to me. Is it clear? Your carelessness caused harm to me. And so you should be liable for that because you have the duty to take reasonable care to ensure that your product does not cause harm, injury, or loss to another. That is a brief way I can explain it. Now, vicarious liability is another form of accountability. And how does it work? Vicarious liability is responsibility attributed to a principal for the acts and commission or omission of his agent. For the purpose of AI, the law considers these systems as agents of their developers. If not, we will have no way to have someone to hold accountable because you can't hold a system. I don't know if we understand what I'm trying to say. Since you can have a hold on the system, you see how you can, through legal doctrines, attribute responsibility to its manufacturer or its designers. And that is how we use vicarious liability. But these forms of accountability are challenging because I would like to mention the fact that liability frameworks were not AI modeled. They were human-centered and simply adapted to adjudicate on AI issues. So if we say it in that way, let us consider an AI system, for example, the black box system. We know that these systems are capable of learning, okay? They are capable of reaching out unpredictable decisions which are contrary to the design of their developers. So if an AI system, for example, causes loss, damage, or death to a victim, as a result of a learning, you cannot use vicarious liability to hold the developer because that was not as a result of a design flaw. The system learned and took decisions which were contrary to its design. You are going to fall back on other forms of accountability, which we refer to as strict liability. Strict liability is liability without fault, attributed to someone simply because another has incurred loss or damage, even if your actions were not reckless nor careless. But the challenge with this form of liability is that it is only awarded for specific forms of risk. And I make this precision because if we have to offer strict liability for all forms of risks, then it will lead to what? Remote claims. Okay? Anyone can just go to court. So in case of misuse, there are several forms of accountability which can be used. It can either be civil or they can be criminal. As far as the criminal part is concerned, we know that I don't know how it is done in South Africa. I don't know if people have a criminal code. Good. So if you commit an act which contravenes the criminal code, is considered to be a criminal offense. Okay. Now the problem with attributing criminal liability or responsibility with AI systems is because for you to be criminally responsible, you need to establish that an act was committed and there was intention to commit that act. So there's always a challenge. How do you attribute that aspect of blameworthiness to an AI system? We now see that the laws which are simply adapted to regulate AI issues are inhibited by a number of challenges because they were not AI centered. So what is done is that we simply see how we can maneuver with them, adapt them to fit the context. So it is very challenging, and I hope maybe subsequently we can have developments in this area of the law. Thank you.
Thank you so much, Hamza. As you were explaining this, I just think about the work we do, and let's hope a lawsuit won't be coming our way as as people work with data, because seemingly it's not just me who didn't know about all the legal aspects of the data that we use, and the consumers, what is the after effects of if the information is wrongly consumed by the consumers or the clients. It's just a lot to take in, really. So now we're going to talk about data sovereignty and licensing, where I will start with Zinzi. What does data sovereignty mean to you in terms of practice of African AI system, and with the experience you have from the legal side?
Thank you. So data it's more than just a technical resource. It's more than just an economic resource. It also shapes decisions on a governmental level. It shapes decisions related to like healthcare, to education, and so forth. So, in the context of African AI systems, data sovereignty essentially means that African countries should have control over the creation of data, the creation of information. They should retain that control subsequently in as far as how that data is used, how it's stored, and how it's accessed. So it's about having control over information in Africa, right? So a concern is that Africa risks losing control over its digital data because there's a significant amount of data, a significant amount of information being exported and being processed in Europe, the US, China, and so forth, right? And it's being done, it's happening like that without any oversight from Africa or without any African voices. So it's like, how are you taking information from Africa and not having that African perspective in how it's being used, right? So it's also it's generating economic value somewhere else. It's generating economic value in other continents. So they'll extract data from Africa and then they'll commercialize it, and then they'll bring back those AI products back to Africa, but like they're not locally sensitive, they're not context sensitive, right? Because they were processed elsewhere, right? So it can lead to biases, it can lead to discrimination, right? Because they do not accurately reflect the local context, socio-economic considerations. So it really raises concerns about fairness, about inclusivity, and about ownership of that information. So in my view, it's very important for Africa to play an active role in really creating information, and that information being used to serve local interests and to reduce the amount of information that's just flowing out of Africa into other continents. Yes.
Thank you so much, Zinzi. And then back to Hamza. We're curating data from South African farmers in Limpopo in a specific language. Another scenario, we have IoT devices that are generating data, let's say for smart water monitoring. Two aspects. One, data perhaps being generated by devices, and one being curated by people for a specific use case. So how can data ownership and licensing frameworks be effectively enforced in these real-world settings? You can also give examples based on your experience and expertise, but it is important just to understand data owner, who owns this data, and what licensing frameworks are there.
Okay, I will say little on that. But as far as licensing frameworks are concerned, I don't have much details, especially with the South African case. But I believe we have what we call licensing agreements, okay, which I think could serve as a framework in that situation. So I can't pronounce myself much on something I have little or no mastery. Thank you so much.
Thank you so much. Then we will go to Hannah. Do current data governance approaches reflect community expectations and reality based on your scenario and experience with your data curation from the Chivenda people?
Thank you. So from my experience from serving farmers who speak Chivenda, there's definitely a gap between how data is governed and the current realities of those communities. Of course, as researchers, we all know that we have to go through an ethical clearance process, which we did. We got our ethical clearance. However, there's no legal obligation to share the outcomes or the results with the participants. And in fact, I forgot to mention in the first question that we had an advisor who works with the community that we were serving. We had an advisor who was always telling us about the cultural norms and all the details that are very important. And he actually spoke about how oftentimes researchers will come into the area, collect their data, and then you'll never see them again. And also, from our knowledge, none of the participants asked where their data is going to be going, what's going to be happening with it. That being said, we still have a close relationship with the advisor who helped us. And from an ethical standpoint, we do plan to share the data with him, not only for transparency reasons, but to also verify if our findings are actually reflective of that community.
Thank you so much, Hannah. I think, Hamza, you'll be excited because you spoke about the black box and system. I think you'll tell us a little more about that. Seems like it's one of your interesting projects. So while discussing about the black box, I would like also you focus on the AI systems. When AI systems produce harmful or incorrect outcomes, where should legal liability sit? You can give context of South Africa, you can give context of the application country of your choice, but just in general, where does this legal liability sit?
Thank you, Siani. I will also recover my time for the other question because there's much to say on this issue. Before I answer your question, I would like to narrate an experience for the purpose of analogy. So there was this incident that happened in Cameroon, a language model system, I don't know how you call it, which translated all the languages spoken in Cameroon, something like that. So it gave a translation which was pejorative to a particular community, and that gave rise to an uprising characterized by multiple casualties. We even had people who lost their lives. So you now understand the importance of law in this kind of situation. We had so many victims, but little did they know that they have avenues which they can take against the developers of this system. Now, the problem here, most of them who are villagers, they will ask you, but what can you do? Huh? Where should you go to? Is it clear?
Yeah.
Who is taking responsibility? And I will equally want to distinguish between this, your question, and the first question which you asked. Because the first question was, what are the accountable forms when data is misused or misrepresented? It is different from when the system causes a harmful effect. Because when we're talking about misuse, we are referring to a situation whereby the system in itself has no problem. We are looking at what the user used it for. It is a different scenario. But with this question, we are looking at the system itself. And that is where we are going to be talking about product liability, which is also a form of accountability. I was struggling not to mention it because I knew this question is coming. So when systems produce harmful content, which are subject to creating undesirable effects to victims, responsibility here lies on manufacturers, distributors, retailers, and I would like to situate it in South African Consumer Protection Act, I think section 61. That's the only document I read so far here. Section 61 of the South African Consumer Protection Act is very clear that producers, manufacturers, distributors, retailers are responsible for all damages, all loss, or any other form of impact in which those products are exert on individuals as a result of their defect. Is it understood? So that is what the law says generally. To relate it to the AI context, it simply means that when developers create a system, if that system, as a result of a design defect or a design flaw, causes harm or injury to a third party, the designer or the manufacturer or producer will be held liable under the product liability regime. And how does it work? The burden of proof here lies on the plaintiff. You have to prove defect in that system. And that is where there's a problem. Let's imagine I am the victim. I have little or no knowledge on tech issues. How will I prove that there was a defect in an AI system? Because for liability to hold, to be established in product liability, you either have to prove manufacturing defect, you either have to prove design defect, or you have to prove marketing defect, for example. It means if a system is highly risky, the designers have to inform its users and warn them accordingly as far as the usage is concerned. So in case we have a victim from a defective AI system, he can only rely on product liability. And there is a difficulty here because we are talking about the black box system here. And we know the black box is characterized by opacity and unpredictability. These systems are capable of reaching context and being difficult to be understood. It is difficult to explain the systems. So if you are unable to explain the system, how do you prove defect? That is where the problem lies. And we equally have challenges such as trans-jurisdictional challenges. A system can be designed or manufactured in South Africa, okay, let's say trained in Cameroon and used in Egypt. It's very possible. So if someone suffers damage as a result of a defect in that particular system, how do you get legal recourse, especially when we are dealing with a trans-jurisdictional problem? How will you take a system developed here in South Africa, how we take that system to court in Egypt or in Cameroon, for example. So these are some issues in which we are confronted with, and we think that Africans, we are left behind as far as AI is concerned from a legal perspective. We cannot continue adapting human-centered regulations to adjudicate on AI-related matters. And I think it is time we understand that we should not only look at the merits of these systems, but we should understand that these systems are so vital to human life because they touch across almost all critical sectors, from finance, human, education, healthcare, and all the like. I think it's time for us to develop an AI modeled and Afrocentric regulatory framework that can address these emerging technologies for the specificities which they have. That is my take on this. So,
Okay. Are there any questions from the audience before we proceed? Reflections, Kenny. Okay. I will do the honors of running up and down like Prof. I don't have energy like Prof, but I will try.
All right. Thank you so much, Hamza. It's a very interesting presentation. I think a lot of the focus seems to be on the usage after the fact or the effects after the fact. I think it was maybe a year ago or 2 years ago, a lot of the major publishing houses kind of came to the realization that a lot of the LLMs were being powered by articles that come from these publishing houses. I'm not too sure what the legal recourse is. How then would, for example, me, if I'm an author, how would I know that if I didn't give consent to OpenAI to use my work and they use it, how do I kind of protect myself against that as an author?
Yeah, I'm coming. I'll be running. Yeah, for the online audience.
So thank you so much. That's a very important question, even though it's directed for Zinzi, but I will assist you on that because I'm equally having some in-depth knowledge on IP issues. So to answer your question, I will give you a small case which was filed at the U.S. court between the New York Times and OpenAI. I don't know if you've read that case. Okay, so you are very conversant with what I'll be saying here. So in the case of the New York Times and OpenAI, we have the New York Times who filed a legal suit against OpenAI, and they are claiming that most of their contents which they write for broadcasting were reproduced by OpenAI. Okay, and OpenAI broadcasted that information better than the New York Times. Better than the New York Times. And you see, we have this tendency of using AI because we think AI can do things better. Yes, it's true that these systems are more intelligent than humans, but in that case, you will discover that that was a case against copyright infringement. And it was so unfortunate for the New York Times because the rulings of the courts were not in their favor. And you will ask yourself why. The reason is it was very difficult for OpenAI, for the New York Times, to prove that part of their content was used by the New York Times, by OpenAI, It was very difficult because for you to hold, because we have just discussed here on the forms of accountability. But I do not want to enter into more technical legal issues as far as how the matters will be adjudicated in court. You, the complainant, have the burden to prove. You must not only prove, for example, that there's infringement, but you must prove that there must be the causal link. You must be able to identify that it is as a result of this, your infringement, that I have suffered this damage. And it is always very difficult to prove, because most of the times, the elements of evidence which you need as a plaintiff or a complainant is in the possession of the defendant. I don't know if we understand ourselves very well. The defendants keeps, like the high-tech companies, they have the evidence which you need to prove to court. So how do we get this evidence? Even though we have other legal remedies which the court can order them to deliver some necessary evidence for examination, but this is time-consuming, and we all know that justice delayed is justice denied. And not all plaintiffs or complainants have equally the required finance to sustain through those legal procedures. So in that particular situation, I just feel like the New York Times might be right in that their claim, but law works with because in civil claims you have to prove beyond probability. Unlike in criminal matters, the proof must be how can I even say it? Beyond all reasonable doubt. So if you are unable to make the balance, to weigh on your side in a civil claim, the rulings cannot come to your favor. And you now see that these are one of the difficulties in which we can attribute these systems to our traditional regulatory framework, because there are some authors who have advanced solutions to that, claiming that for the purpose of artificial intelligence, we can see how we should shift the burden to the defendants. So it means if you make a complaint against a high-tech company, let the burden of proof be placed on the tech company to come and prove the contrary to that assertion, and not the other way around. The legal principles for now are clear to that effect, that you, the plaintiff, have the burden of proof to prove what you claim. And if you're unable to prove that, I'm sorry to say that the ruling will not favor you, even if you have been infringed or offended in a particular case. I think I've approached that question in the best way.
I want to add.
Oh, okay.
So I want to bring up the case of bots versus Anthropic, which is a recent US judgment wherein basically a number of plaintiffs claimed that Anthropic used millions of their works to train the, not sure what Anthropic's model is, but Claude. So they used millions of work to train that model. So there was a distinction between so Anthropic, essentially, there's the part of the training material which they legally purchased, right, from publishers and so forth. Then there's the part of the training material which was pirated, so it was obtained unlawfully. So what the court then said was, because the US uses the fair use doctrine, so fair use essentially allows you to, fair use, fair dealing, it allows you to use works without permission for a specified number of purposes. So for research purposes, you can use those works without having to obtain permission. If you're studying in your room, you don't have to obtain permission. But if you're gonna use those work for commercial purposes, then you need to get permission. So the US court essentially said that for the part of the training material which was obtained legally, it is not necessarily infringement. It was transformative. The way that they used the material, they essentially, it was just transformative. It transcended the way the works were before. Now it's a completely different thing, and that's allowed. And then in relation to the pirated works, the court said this is inherently bad, right? It's just bad on its own. You can't just take things unlawfully and then subsequently use it for legal purposes, right? So you need to get that permission first. And if you don't, then, oh well, infringement.
Okay, back to our panelists. We'll open again the floor for questions after Hannah and Zinzi answer the following questions. Hannah, what are the real world risks to the communities? For example, the communities you worked with, when AI systems are not transparent or understood. I know the legal experts have already mentioned or highlighted much from their side, but maybe from their experience with you collecting data from the communities in Limpopo, what are those harmful or incorrect outcomes in terms of also agricultural data? I think that it would be nice to hear that.
Thank you. So I'm specifically going to be talking about the data that I collected and my experience. So the risk is extremely high for when users don't understand how the AI works and don't know how to use it. Just for using an example in agriculture, let's say a farmer asks ChatGPT to provide a pricing strategy for them. And this aspect we actually explored in our survey. And ChatGPT generates a hallucinated strategy that is actually completely inappropriate to their context. That could seriously harm a farmer and almost put him out of business, actually. And then when you add in the subject of low resource languages, as we know, Chivenda is a low resource language. And from the data, a majority of participants indicated that they had poor to basic understanding of English. And also translation tools are unreliable at the moment. We got our survey professionally translated, but when I back translated, I don't know if everyone knows what back translated is, but I'll just say. So back translation is basically a quality control measure where you take translated material and translate it back to the original language just to see, using another translator tool, just to see if everything is correct. So basically, I had taken the material that had been professionally translated and put it into Google Translate. And one of the questions had been asking about what events have you noticed that have climate change impacts? And lack of wetlands had back translated to lack of menstruation. So that was very interesting. So when you add that to users who don't understand how AI works and that it does have the tendency to, or the potential to generate hallucinations, and also that, you know, AI is using your data to train itself again, there's major risks there. Which is why it's so important to include users in, and also educate users on how to use these tools. Because, again, sorry for my data, participants did indicate that they were interested in using advanced technologies. But then when we asked them what they were using their phones for, 100% said, or everyone said that they were using it to make calls, but a minority were using it for work-related tasks or learning apps. So, yeah.
Interesting how wetlands are related to menstruations in Chivenda. Wow. I don't know what data is those systems being fed and how is it interpreting the context there. Zinzi, are the current governance and policy frameworks sufficient to support the responsible deployment, or are there critical gaps?
So there are critical gaps. There are very big gaps, you know, because as Dr. Monkari said, the current legal system is not designed with AI in mind. So the issues that are coming up with AI, courts just kind of have to slot them where it's relevant, but it's not. These legal systems, they're lagging behind, right? They're not calibrated for AI problems. So there's just that need from a legislative level from a policy level to really critically think about how these legal systems should apply to AI, you know, on a copyright level, on a liability level as well, because on a liability level, there's also, you know, problems about causation, black box, you know, you don't see what's really going on inside the models. So how can you link a specific action and the harm that subsequently happens? So there needs to be that clarification about causation, about which liability schemes can be used. Is it product liability, strict liability? You know, how to really recalibrate these legal systems to fit in the problems that come with AI, because they're severely lagging behind.
Okay, felt like it was a low class for me. Closing reflections before we open the floor for questions. What is one key principle needed to ensure ethical, lawful, and responsible AI deployment in your current work, or if you have a real use case scenario to give, so that my audience can at least have a takeaway point from what you've discussed today? We'll start with you, then you go to Hamza and Hannah.
For me, I think it's about interdisciplinary perspectives. You know, we need perspective from the legal side, we need perspective from the computer science or the data science side. We really need those voices to come together so as to really regulate these issues on a more comprehensive basis. Because if you have just lawyers there, then, you know, we have people then designing the law for things they don't fully understand. And if you have just, well, you wouldn't have data scientists doing the law. So there needs to be that interdisciplinary consultation. And another thing that I want to add is inclusivity. So we need to have real life voices, right? We need to have the voices. We need to have people's voices, right? Because you're designing these systems, you're designing these laws that are going to serve the people. So participatory mechanisms are really important to get the people's perspective on how the law should go, right? Because also, maybe if you let government do the laws thing on its own, then you have the laws that serve just the higher up people, right? But if you have the citizens then chipping in, then, you know, the solution is also serving the people as well, rather than, you know, people at the high top, like most laws in the country. Yeah.
Okay, I will just add more to what she says. I will corroborate your position. I think I equally had the idea of inclusiveness to elaborate on, because when we involve every stakeholder in the decisions and the regulatory framework which we adopt to govern all of us, it fosters compliance. Okay, so if we all agree to be governed or to move on this pathway, then I believe we will feel included in those rules, in those regulatory framework, and this will in turn foster the responsibilities of those systems, because we are also going to chip in, we are also going to explain our experiences and contribute on how things should be done. And if all agree on how things should be done, then I think all the ethical and legal systems put in place with their regulations will be up to standard and will reflect the human communities. Thank you.
Thank you. Okay, I think I'm going to sound like a broken record, because I'm also going back to what I said is the inclusion of the community that you are researching. They need their interests need to come first, and their perspective needs to come first. And also from my perspective as a business management PhD, we are always asking ourselves, what is the socioeconomic benefit that my research output is going to provide? Or is it just going to waste away on a shelf, what is the actual impact? And then I also want to build on to what Zinzi said about interdisciplinary work. We need to prioritize interdisciplinary work over siloed work, because that's not, life isn't in silos. Everything's all together, interconnected, and working together in an interdisciplinary nature and manner, that's how you can really maximize your real world impact.
Okay, so we'll open the floor for questions before I give closing remarks. Questions? Marisa.
For those working in law, many of the languages that we work with in South Africa are cross-border languages as well, meaning our other countries on the African continent share the same data scarcity issues and share the same prioritization of creating data sets for those languages, although each have their dialects, but they are useful for each other. And I was wondering, we talk about creating policy and laws for the South African context, but wouldn't it serve us also to create those same policies on a continent level, because we do have languages that are spoken in more than one country and can benefit from collaboration across countries, but they need to be protected in all of the networks associated.
Say something. Oh, yes, thank you. I followed up that. It's more of a comment, so it's a question, but it's okay. Let me throw more light on that. If you were keen, I mentioned one of the challenges I was talking about, trans-jurisdictional issues. Yeah. So in my recommendation, I equally recommend for some kind of regional or global collaboration to see how they can address issues common to a particular group of community. With the case of South Africa using data from or languages from other places, I would like to find out how those languages, how those data was taken. Yeah, if they were taken legally, then I think there's no problem. Because sometimes we see data mining. I don't know how it is done much. I don't have a lot of tech information, but I just know that some of these designers, they go and plant sensors somewhere, obtain data without the knowledge of those communities. And that's why I said from the beginning that we don't have a unique legal framework on AI. They are fragmented. With this particular case, we can have laws regulating data privacy. I think in South Africa, you have something like that. Yes. So I don't know what those laws says, but we have rules on collecting data, maybe established in various countries. So if you have to obtain data in those countries and you pass through the normal channel and mechanisms, I believe you will equally know how to use those data. And if it has been done respecting the mechanisms of those member countries or of those countries, then I don't think you have any legal problem.
Can you maybe also highlight the license that was developed in your lab in more details and what it can be used for, and the Noodle license?
I cannot develop on that.
So the Noodle license basically makes a differentiation between users in Africa and users in the other continents. So when it's being used by African users, it's just more permissive, right? More permissive. And then when it's users from the other continents, it's more restrictive. It requires the benefits to flow back into Africa. You know, if you take that information and use it in those other continents, there's that requirement for the benefits that flow from the use of that information to come back to Africa, right? So, yeah, and I think I want to add that in relation to copyright law, there's not a lot of differences in copyright law, right, across the continent. It's essentially the same because it is based on the Berne Convention, which is like an international standard, right? So it gives member states the same kind of obligations. They're supposed to protect the same kind of works. Infringement is determined in the same kind of work. Fair dealing is the same. So copyright law is essentially the same. So if like it's the same. So in other countries, you'd still have to get permission from the communities. You know, you still have to get that permission from the authors, from the people who made that data. Yeah.
Kenny, not now. There was a question at the back. Kenny, you should be answering those questions, by the way.
Oh, okay, I just want to make a comment, just to appreciate all the panelists. I just want to add one or two things. I think that with the increased tendency for AI to permeate every aspect of our lives going forward, in Africa, there is need for stronger advocacy for establishment of AI laws. I mean, there are countries of the world where the thinking is already along those lines. For example, we have the EU AI Act that actually guides the development and the use of AI systems. Some other countries like Brazil, North Korea, even Canada have such. Even in Africa here, I'm aware that Nigeria and Kenya are actually thinking about that. South Africa is also not totally out of it because those discussions have already started. But there's a need for stronger advocacy along those lines because there is no way we can actually use human laws or what we have now, to actually serve for the purpose of AI systems. The other point I want to make, which I think also relates to most of us here, is also the aspect of education. Even in education and training, a lot of professionals being trained, particularly in fields like computer science or software engineering, are not even educated on the ethical aspects of software development. For example, you are trying to build a system or you are trying to design an algorithm. It's easy for you to think of, okay, what are the business requirements, user requirements, system requirements? How about the ethical requirements? How about this AI safety requirements that system or that algorithm needs to fulfill for it to be fit for use, maybe in a bank or in any other type of environment? So the earlier we get on this, the better, so that it can affect everybody, not just people in the legal domain, but even as we train, young academics and also students that will become professionals in the future. Thank you.
Okay. So it's more a comment on the idea of interdisciplinary or transdisciplinary research. It's for Hannah. How do we foster that? We have two people in the legal field and one person in, the business field. Where are by show of hands, any biologists? Any linguists? Okay, great. So that's some interdisciplinary kind of environment. But how do we foster that? How do we initiate those connections between different fields and kind of integrate, AI and data science into different fields? How do we build those relationships? Yeah.
A comment? So I'm just gonna maybe just make a comment. Thank you again for inviting us. It was really interesting because, as much as we stuck at the desks and counting money and looking at figures, you get the sense that most corporations don't want to fall behind in terms of AI. So we always requested that, we need to be up to speed. We need AI in the banks. No corporation wants to fall behind. But then you get the sense that maybe we are not that mature And maybe I could, be incorrect, but it's the sense that in terms of feedback to our corporations, is it fair to say that we are not there yet? There's many things we still need to consider before they go into the rush of putting these sort of things on our mandates and strategic for the future, that AI has to be implemented for better customer experience. But for what I've learned today, it sounds like there's still more work to be done before we can, start introducing some of these concepts to our customers and potentially affecting some of these world system banks and financial systems through AI. But just as a comment, again, thank you for the very informative discussions. But it'll be nice just to just get that summary so we can provide feedback for our corporations to say that, we learned a lot, but the summary of the entire discussion is we are not there yet. It's best that we hold on and we make sure that once African languages are incorporated, AI is there, then we can start working on it. Thank you.
Yes.
All right, I just want to ask an obvious question. Who owns data? Especially from the legal standpoint. The data that is available, for example, a bank publishes their end of the year report, and my AI system picks it up and learns from it, trains using that data. What's the legal standpoint? Who owns that data? It was made available, made public. From a legal standpoint, who owns data that is available on the internet?
To answer that first. Who owns data, Prof?
Sorry, I'll go to the front. Yeah. Okay. No, but I think you would be the best people. I'm not the league. No, each content is created by somebody at the end of the day, which means that it has copyright that is connected to that. And then at the same time, people might then provide a license that says you can access this data in this way. So maybe an interesting part in thinking about this question is connected to maybe the right to research part. So on the right to research, in thinking about this thing, and I'm not a lawyer, just hang out around them a lot, is to then say that if on the right to research pieces is, I should be able to access specific types of data, let's say non-private, very, low risks and safe, to be able to do studies and look at them for different reasons. And some people might say, no, we don't want you to do that. And this types of either right to research or fair use in some countries is not necessarily universal around the world. So an argument might have been made by a very big a company that said that they built an LLM by taking scripts from the internet, and as such, for them, it's fair use. But then there's fair use, and then there's a concept of fair dealing. If you then take somebody else's content, and then on the other side, you create something, and now you are making, there's some economic activity, now the fair dealing comes in and says, like, the person who then created the content on the other side, how then do they now connect to this benefit? Right? So that's where now the whole part, we go back to the copyright. Now, what would happen typically is that now when you are a researcher saying, I'm going to do something, you then will say, I'm going to now be very important to look at the copyright. Whatever the license that the person has released this on. So for a lot of people, if you've got CC0 or CC BY, that is great because it doesn't really touch on what you create after as much in terms of when you do the transformation. But then if you have something like CC BY SA, if you have Noodle, if you have SA2, they then say, if you create something, you must share it in the same way. So you must release it also publicly and under that license. You can't adjust it. We have our friends from UNISA. I'm not going to pick on them, but I have to point out one. They have a robotics glossary. That it's on the UNISA library, but then it will say CC BY SANC. So the NC says you cannot use it for a commercial purpose at all. Right? I then might say, why did they put the NC? They could have left it at SA, because in most intents and purposes, that actually does the same thing. Because a person who wants to necessarily do something commercial might not want the carry through that they have to release their data in the same way. So the NC seems much more restrictive than it really sounds, and some people might be scared. I haven't talked to UNISA, so I don't know what the discussion might have been. While then, for like ASETU, which comes from LAPA, and I have to declare I'm one of the co-founders, says that, okay, we'll kind of discriminate in a way. That's the right word here. If you're African, you don't need to worry about that. You can use the data for whatever reasons. Go ahead and just attribute the way you got the data. You don't need to carry on. If you're not African, you then have to then abide by the SA part. And then if there's a benefit, you must engage with the community that created the data to say, how then does benefit share? Noodle does something similar, but then via, are you in a developed or developing country? And all of these obviously are open to interpretation of where initially when people were creating what they would mean. But that's the reason this year there's going to be many consultations by Creative Commons, the people who created these licenses, because they believe that the initial licenses that they have are no longer suitable for the landscape. The reason that you've asked this type of question, I think. I yet have not answered your question in terms of something like Common Crawl or FineWeb, these web data sets where people have just went all over the internet and scraped the whole internet. And that will likely be, depending on what is it that you're going to use it for, right? As I said, like you might look at right to research or say, I'm trying to study how Africans speak about, write about medication for a paper. I'm not really going to go off and then start making a product that then gets sold. But then if somebody else, then you go and you say, I'm ingesting it into an LLM and it has my copyrighted material inside there, then they might pursue you and say, like, you've used my content without my permission. So these are spaces that researchers have to navigate and sometimes are not clear on first thought. It just depends on, I think, intention on one, but then also the reality of what you see. And then, so some companies will just tell you, if it's not CCBY or CC0, we're not working with your data, right? Because we just don't know what might happen later on. But then in order for us to still study ourselves, we also still want to think. So that's why part of our work is that we did donate some URLs to Common Crawl, and now you'll see more African content inside there. But then it also then on the other side, as I said, it touches on what is it that you're doing with that data, change that, and then hopefully. So I'm not a lawyer.
The only thing I want to say is that we are more than fit for legal practice.
There's another question. Where? Oh, okay. Who wants to?
I don't really have a lot to say for that besides conversations, like let's gather together, let's speak about the stakes which are involved. Let's really have a conversation about these things and let's act on that.
Okay, and there was a question, are we ready? Are we AI ready? Are you going to, okay.
Can you ask a question about interdisciplinary?
Oh, okay.
I just wanted to make a note. Okay, sorry. So I'm not in any power to foster interdisciplinary research. I just know my research and what I'm focusing on. My work is very interdisciplinary. I think it was Marissa who asked me at lunch, you're from business management and you're focusing on agriculture. What are you doing here? Because I'm focusing on agriculture and digital tools and climate change through the lens of business management. I just think it's important to have people that don't look like they should be here, because that's how I don't know if that makes sense, but that's how we start to actually spread the impact of the work. I mean, it's all good and well to have a bunch of AI developers saying like, we should do this, or a bunch of linguists saying we should do this. But when you have other people in it, that's when you start to understand it from a more realistic perspective. I mean, even if I look again at my research, you can say, I think that these people will have this opinion, and it can be completely different. So that the only way that you're going to actually move forward is through integrating all different types of research together to move towards a solution that you are moving towards. So that's me.
I think we had one last question. Are the industry AI ready? Does anyone who wants to answer that? Okay, if not, I'll just briefly talk about it. I think it's not a yes or no kind of solution, because there are a lot of aspects to take into consideration. For example, this afternoon we discussed a lot about the ethical aspects and the health, not the health, but rather the law aspects that you need to consider while deploying your AI systems. So I think when going back to your companies, as you've mentioned, going back to the company, what do I say? Are we AI ready? There's just a lot of aspects to take into consideration. What about the data we are using? Are we ready to can take ownership? Where did we collect this data? Can it be reused by other people for research? Can it be commercialized? So there's just a lot of aspects to bring into consideration from different aspects. So I would say yes, no, depending on your use cases, but it is also a work in progress, and it's not a silos work as mentioned. Collaborations is available in-house. Everybody here is willing to collaborate with everyone. So I have 37 seconds left. So these are my final remarks. We indulged in a lot of conversations this afternoon on ethical grounded AI. And I think, as a moderator, from the reflections that we received from the audience and also from the panelists, African AI should not be extractive. It should be stewarded, ethically grounded, and it should be legally sound. Based on the data sets that we used, and it should be responsibly deployed, as Hamza mentioned about some of the use cases of not deploying it well, and then there can be some problems with the consumers of the systems that we deploy. So if there is one takeaway that I will take from this panel this afternoon, is that African AI cannot be built just solely on extraction. It must be built on stewardship. It should be grounded in ethics. It should be supported by law, and it should realize or be realized through responsible deployment. I think that's all from our side. I think we used all our time and we're 34 minutes late. My panelists, thank you so much. It was great engaging with you guys and hoping to engage in future. Thank you.
Thank you.